Please be seated. We'll hear argument in 21-784, Fraley versus Texas A&M.
Please the court. Mr. McSwain will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court, Andy McSwain for Christopher Fraley, the petitioner in this case. This is as you know, a Tort Claims Act case that involves the intersection of the premises defect, special defect, and discretionary standards under the Tort Claims Act. The facts are relatively simple. Christopher Fraley is a deputy sheriff. He was on the Rellis campus of Texas A&M for firearms training. That lasted into the evening, so he was exiting the campus at night. As he was exiting the campus, he came to an intersection on the campus that had previously been a four-way intersection, and within the month before that event, Texas A&M had taken out one of the stretches of roadway and turned it into a three-way T intersection. There was no warning, there was no marking, there was no guardrail, there was nothing to designate at night that that was a T intersection.
There's a picture in the record that indicates there's a yield sign that was facing the driver as he approached the intersection. Is that accurate?
Yes, sir, that is accurate. But I would point out that the yield sign, there likely was a yield sign on the other stretch. There likely was a yield sign on the other side as well that was taken out. We don't know that. But that yield sign would be...
So why does it matter what the roadway looked like a month earlier to determining whether or not there was an existing premises defect on the night of this accident?
That's a good question. The court, in its writings on premises and special defects, Cameron County versus Brown, for one, has said that you have to take into account the existing circumstances of the particular, whatever the dangerous condition is. That's part of the existing circumstances of that dangerous condition. The recency is also a factor with respect to, that's listed by the court in numerous opinions, one of the 4 or 5 factors that determine whether or not a special defect, whether it is or is not a special defect. For instance, there are cases, and I can't call it off the top of my head, but there are cases that say if it's a permanent issue, then that's not a special defect. But something that is recent may well factor into the objective expectations of an ordinary user of that roadway.
Would it be for this ordinary user who was unfamiliar and had not driven in this area? It was an unfamiliar area to him. So again, wondering why the fact that it used to look like something different mattered that night.
So the record doesn't support that type of argument, actually, because we're here only on a challenge to the pleadings. This was not an evidentiary challenge. There's no showing in the record that Mr. Fraley either was or was not familiar with that particular intersection. What the record does show through the pleadings is that Mr. Fraley pled that he was not aware that the other side of the roadway, up and over, had been taken out. And if you can see from the picture in the record, you couldn't have seen that from where he was, from where he entered that intersection.
So if the road had been built that way all along, it had been a T intersection from the very beginning, there would be no problem.
I believe that it is likely that if it had been built that way all along, that would be frankly, a design issue that there would not be liability for, except for the potential of a special defect. For instance, if you had an unmarked T intersection that had a 10-foot drop 1 inch off the edge of the road or 1 inch off the shoulder, my suspicion is that might qualify for a special defect if there's not any warning. So I can't concede that T intersections, and I do not believe that T intersections are always immune from liability simply because of the fact that they're T intersections. And frankly, Purchase, the relatively recent Supreme Court case, Purchase is a T intersection case, but there the court made the point that the guardrails that were hit when the driver missed his turn actually it's not guardrails, it was a concrete barricade, actually was the limiting factor on the roadway. And so it couldn't have been a danger it couldn't have been a danger based on the objective expectations of an ordinary user of the road, because an ordinary user of the road would have turned before he got to the concrete barricade. So purchase does not establish that all T intersections are immune from liability.
Wouldn't the ordinary user slow down enough because of the yield sign to see that it's grass and a ditch on the other side of the road?
Two answers to that. Number one, again, this is a non-evidentiary attack on the pleadings. And the pleadings themselves under Miranda do not affirmatively negate, actually three answers. They do not affirmatively negate jurisdiction here. The second answer is if you look at the picture in the record that has the yield sign and shows the ditch is up and over the crest of the road. I'm not sure that the driver could have seen that at all, but it's certainly not reflected in the record otherwise. And third, with respect to a special defect, one of the elements of the statute is not, was the plaintiff contributorily negligent or not? I mean, it is either a special defect or not. And
The
so,
position is that the ditch is a special defect, just in its nature, right? And I'm wondering whether the yield sign has to affect, I mean, really you're complaining about the design of the intersection in light of the past design, and the yield sign has got to come into consideration. I mean,
the yield sign has to come into consideration, but again, on a non-evidentiary basis, I believe that the yield sign, is not determinative of whether or not there's jurisdiction or not. And beyond that, I know that one of the issues that the court, or at least I believe that one of the issues that the court is looking at is that the design, whether it's discretionary or not, does that sweep away all the potential of liability in this case? And I say to you that it does not, because the .056, the overall general discretionary exemption in the Tort Claims Act, has to be subject to .060, which is which speaks of discretion with respect to traffic devices and warnings. 060 specifically mentions discretion and specifically exempts the failure to have warning devices as a discretionary matter for which there can be no liability, and then it goes on to delimit when there can be liability, when there is a waiver of immunity, and special defects are one of those instances under 056.
But doesn't the special defect have to be so, either on or so contiguous to the roadway that an ordinary driver on the roadway couldn't hope to avoid it? And so, in purchase, we said the reason there was no premises liability there is because the driver missed the turn and proceeded off the road. And so here, is this not, approaching an intersection and missing the turn?
Yes, ma'am, it is. It is approaching the intersection and missing the turn, but the difference is in purchase, the concrete guardrail was what the driver hit, and the concrete guardrail defined the road. Here, there was no concrete guardrail. Here, there was nothing but a ditch.
What do our cases say about what we look at? What do you consider the best authority that we should look at to say what the roadway is? I assume it's not the subjective intent of Texas A&M because about what the roadway was going to be, because the driver wouldn't know that.
So in looking at these cases, and I've got a list here, I've read every single one. In looking at these cases, it seems to me that the court has fashioned a good test when you look at the objective expectations of an ordinary user of the roadway. Because what that prevents is having to go through logical gyrations about what is and is not actually the road. For instance, Rodriguez cites to the Morse case. Morse involves a 10-inch drop-off between the roadway and the shoulder that very clearly was held to be a special defect. Now, it wasn't on the road, right? So do we have to go through the logical gyrations of deciding whether or not the shoulder is on the road or not? And if it's an uneven shoulder, what part of that is on the road? If you look at the court's cases, beginning with Payne, which is cited in nearly every one of the Supreme Court's discussions of special defect or not, the footnote 3 cases in Payne all are reconcilable with the objective expectations of the ordinary user of a road. The very first case that Payne notes in that is a case called Chappelle, where a guy's driving along the road, driving down the road. He sees some brush. There's some brush on the right-hand side. He turns into a gap in the brush that he thinks is another road and runs off into an arroyo, a ditch, right? Very clearly off the road. But the Payne court said in determining that there could be special defects off the road, okay. But where that falls into is, was that an ordinary expectation of that driver on that day under those circumstances? And yes, it was. The same thing for the City of Houston versus Gene, which we have cited in our brief. Unmarked, unlit, dead-end road ends in a ditch, 4 feet from the road. Same situation. Ordinary. Yes, ma'am.
Are those cases a little bit different, though? Because in those cases, the roadway simply ended, as opposed to here, where there was an intersection, which might alert an ordinary user to the fact that the roadway may not continue.
If there was an indication here, which there was not, that the roadway actually ended, then that might be correct. Here, there was no such indication. There was no, and again, we're not talking about the placement of warning signs about a T intersection or not, which frankly should have been done as the right thing to do, separate and apart from whether or not there was liability.
What if there was a stop sign?
I don't know. I don't know the answer.
What if there was
to
a red light?
Again,
Would
that doesn't.
would it be a special defect if there was a red light?
I think that's one factor that would factor into the circumstances, but I don't know.
Work with me that the answer is no, that if there was a red light, then this setup would not be a special defect. Doesn't that mean that you're complaining about the difference between a yield sign and a red light, which is exactly what 060 says you're not allowed to complain about?
And I don't believe, and respectfully, I don't believe that that's correct, because I'm not sure that the record, again, we're here on a challenge to the pleadings only. There's no evidence in the record about what you could or couldn't see from where Mr. Fraley was stopped on the road heading into that intersection, one way or the other. There's no evidence in the record to show that he could tell that the road across the crest of the crossroad had been taken out. And so I can't tell you honestly, if there was a stoplight or a stop sign, would that make a difference? Because I don't know.
Is there evidence in the record that there are maps that show the road continuing on or anything like that?
There is no evidence in the record about anything other than an admission by the state that this had been done a month before.
Because there is no record, right? We're here on the pleadings.
We're here on the pleadings alone. And under Miranda, if it is, since we have not affirmatively negated jurisdiction under Miranda, we at least get a chance to replead.
What would you replead?
What we would replead is we would have the opportunity to replead if for instance, if the road had not been built according to the design. I don't know the answer to that question. I don't know if it was or was not. We could replead. We plead generally that it was we plead generally the circumstance and plead generally that it was a special defect. We would replead exactly how far off the roadway it was, exactly how deep it was, and whether or not Mr. Fraley could or could not see as he approached the intersection.
The Act's language has been difficult to apply over the years.
Yes, sir.
That said, it seems a little odd to refer to any dangerous off-road condition as a, quote, special defect. That seems like just an ordinary defect. And you would focus on the danger and the expectations, but we've always said special meant like special excavation or obstruction, unexpected.
I believe that that's accurate. And frankly, the court's writings reflect that, because in these writings about special defects, the courts has said there are 4 or 5 factors, right? Permanence is one of them. If this had been done a year before, you would expect an ordinary user to know about it, right? But that's one of the, but those things, just like the unusual or unexpected language that shows up in these cases, as has been pointed out, those things are not in the statute. So you would expect that the determination of a special defect, which is what the legislature intended as kind of a safety valve for these situations, that's why it has a heightened standard, you would expect that it really be something out of the ordinary. But that is determined on a case-by-case basis, according to the court, a very viable test, the ordinary expectations or the objective expectations of an ordinary user, not the subjective expectations of anybody.
You said an ordinary user would likely know about it if this had been a year rather than a month.
Yes, sir.
So who is the ordinary user?
I believe that the ordinary user is like a reasonable person. I think that it varies from case to case.
But it's someone who comes with knowledge and experience of this area? Is that the point? I mean, the year, it's not somebody who's coming from California and wasn't here a year ago, wasn't here a month ago, wasn't here a day ago.
I believe that the ordinary user takes into account the circumstances of whatever that situation is. And so, and yes, I mean, I think an ordinary user can vary within a range, just like a reasonable person can.
But does that mean, though, that from the perspective of someone who's coming from out of state, it may as well have happened a year ago, right? Because that person had no experience at all with it. That's an ordinary user, I suppose.
That may well be, but that also may have to do with frankly, the unpled and not represented in the record physical attributes of whatever that intersection was. For instance, if a person coming from California couldn't see over the hump to know that the road was gone on the other side and there was no warning otherwise, I'm not sure what they would think.
Any other questions? Thank you, Mr. McSwain.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Mendelson will present argument for the respondent.
Mr. Chief Justice, and may it please the court. Fraley has not pleaded a waiver of sovereign immunity in this case. His special defect claim fails because a T intersection does not meet the statutory text definition of a special defect. His premises defect claim is barred by the discretionary exemption, and he should not be permitted to replead after he has pleaded 3 times, including after Texas A&M filed its plea to the jurisdiction. I want to begin by first noting a flaw in Mr. Fraley's pleadings, then address the special and premises defect claims, and finally discuss why Mr. Fraley should not be allowed to replead. First, Mr. Fraley's counsel just stated twice that this is a case that should be decided on the pleadings, and that's correct. But on page 212 of volume 2 of the clerk's record, there is no mention of a ditch in his live petition, nor is there a mention of a ditch in any of his previous petitions. And that was the basis on which the Court of Appeals also ruled on pages 9 and 10 of the slip opinion. So for that reason, because Miranda held that when a plea to the jurisdiction challenges the pleadings, we determine if the pleader has alleged facts that affirmatively demonstrate the court's jurisdiction to hear the cause. And for that reason, as pled, there is not a ditch at issue in this case.
If there was a ditch, he could go forward?
If there were a ditch, it would not be a special defect and it would not be a premises defect in any event.
Why? How do we decide what the roadway is when there's nothing that you can see that says whether something is or isn't part of the roadway?
Well, the burden is on Mr. Fraley to invoke the court's jurisdiction, so we have to look at his live petition, which is the third amended petition. But all that says is that A&M had removed a stretch of roadway. So to the extent that there's a pleading deficiency, that would suggest that the judgment should be affirmed. There are 3 reasons why this is not a special defect, and I want to be sure to discuss all 3 of them. The first is that a T intersection is not in the same kind or class as an excavation or obstruction on the road. The statutory text at 022B of the Tort Claims Act explains that a special defect is something such as excavations or obstructions on highways, roads, or streets. But
so if a city or a county, whoever owns the road, if you've got a 4-lane road and there's 2 lanes going each way, and a city decides to take out 1,000 feet of 1 lane, and they put a little strip of grass there where it starts, and so you've got to get over if you want to stay on the road, but there's no markings of any kind. Is that a special defect or not?
Well, that would not be an excavation and that would not be an obstruction. And I think that would also...
That's not an obstruction?
I think that would also... I think the other reason is that would also involve the court's ordinary user test. In the ordinary user test, if you look at Bainan, Purchase, and Hayes, those cases collectively suggest that an ordinary user is one who stays on the road and one who follows the design of the roadway. And if an ordinary user is going to stay on the road, as those cases suggest, then that would mean that an ordinary user would be one who stops, or in the language of the Hayes case, turns back and takes an alternative route. That's what the court held in the Hayes case when there was an obstruction on the road.
So is the roadway determined by what Texas A&M subjectively intends that the roadway will be, or is it what an ordinary user would perceive that the roadway is?
It would be determined by what an ordinary user without subjective knowledge would determine what the roadway is. And in this case,
And if there's no visual clue to see that this part of the road stops, and that there's an excavation there, then you would still say no liability?
Well, of course, the road ended at a T intersection, and a T intersection has a left turn and a right turn, and at the front of it, the road ends. And in the
But we don't know any of that from this record, right? We don't know if there was a left turn lane or a right turn lane. We don't know if there was a curb. We don't know how far off the road the excavation, how far off what Texas A&M thought the road was, the excavation was. So how do we know that an ordinary user would have said that the excavation is off the road?
I guess two answers to that, Your Honor. The first is if the court is concerned about a pleading defect, this is already the third amended petition after A&M filed its plea to the jurisdiction, which was in response to the second. And this court held in Harris County versus Sykes and in the Motson case that under those circumstances, the court should simply dismiss the case with prejudice. But I think the more direct answer to your question, Justice Busby, is that if the road simply ends, then an ordinary user should know to turn back or take an alternative route.
Even if they can't see it?
The issue of if they can't see it, I think, would invoke the court's discretion, or the statute's discretionary exception about failure to place lighting. But if there's a failure to place lighting issue, that would squarely come in within the discretionary
Well, what if it's
exemption.
because of a hump?
If it's because of a hump on the road, then I think there would be two issues there. The first would be whether that's a special defect or whether that's a premises defect. To the extent that that's a special defect, I think the answer you would then have to look at the court's four-factor test that was discussed in the Hayes case.
So what I'm gathering from your answer is that there never is a special defect.
Our position is not that every single thing off the road can categorically never.
But again, how do we know whether it's off the road?
If there is a pleading defect, I think the answer is the case should be dismissed with prejudice because it's Mr. Fraley's burden to invoke the court's jurisdiction. So if we don't.
Well, and in connection with that burden, you say that, it's a pleadings case, you both say that, but Mr. Fraley provided some evidence, including a couple of photographs, and there's some smattering of deposition excerpts and things like that. And so once those are adduced, can't the court consider those in connection with ruling on the plea to the jurisdiction? In other words, if the photographs indicate that there's a ditch, the fact that the petition doesn't say ditch, we can fill that in with the evidence that was submitted.
I think there are two answers to that. The first, of course, is that the Miranda case holds that the court is supposed to consider the plaintiff's pleadings. And there are two types of pleas to the jurisdiction. The first is a pleadings-based plea, and the second is an evidence-based plea. Because Texas A&M was master of its motion, because Texas A&M filed the plea to the jurisdiction and chose not to introduce evidence, we don't think that under Miranda a court could change could change the type of motion from an evidence-based plea.
So if the non-movement chooses to respond to the pleadings-based plea with evidence, you're saying that the trial court could not consider it and that Court of Appeals can't use it in connection with ruling on the plea?
Perhaps not under Miranda, but if the court wanted to consider the evidence in this case, and as the court referenced on pages 259 and 260, volume 2 of the clerk's record, there are photographs of the intersection. And to the extent that the court wants to consider those, I think the answer is still that this would not be a premises defect or a special defect because of the court's holdings in Purchase, Bain, and in Hayes. Because those cases collectively suggest that an ordinary user is someone who has to stay on the road, and additionally, because the cases that Mr. Fraley relies on, he alluded to the Jean case and the Estate of Sicha case, don't help him. And
Did the plaintiff proffer the photos?
The plaintiff proffered the photos, yes, that's correct.
I'm struggling to see why you wouldn't want us to look at that yield sign.
If the court were to consider the photos, yes, we do think the yield sign is helpful for our case, and the reason for that is of course the discretionary exception. As a yield sign would suggest to an ordinary user of the road that they might need to stop there, or they might need to look before they continue driving. So yes.
Well, and is there any evidence that he didn't do that? I mean, there's no evidence, but is there anything in the pleading to suggest that he didn't do that?
The pleading just says that he continued on into the ditch. The pleading never actually mentions the yield sign, although of course the yield sign is in the photographs.
Yeah, I guess, I mean, as an ordinary user of the roadway, if I can't see, maybe I would go slow, but I don't think a yield sign would suggest to me that the road ends.
It may not. Of course, there is a distinction between a yield sign and a stop sign, and it may not suggest that the road ends.
Well, even a stop sign or a stop light, how would that suggest that the road ends?
Well, a yield sign would certainly suggest that one is supposed to slow down and look for traffic.
Sure.
And if one were to slow down and look for traffic, as an ordinary user of the road would do following the yield sign, one might also very well see that that was in fact the end of the road.
But
And I
maybe
guess-
one wouldn't see that. That's the problem. We just don't have enough evidence, do we, to know for sure. If you see a yield sign and it telling you not to cross when there are people coming the perpendicular direction, okay, there's nobody coming, you proceed. Why is that something that on a pleadings case like this, we would not give the benefit of the doubt to the plaintiff?
If we were going to give the benefit of the doubt to the plaintiff, that might defeat the coterminous immunity from suit and immunity from liability. That is how sovereign immunity is set up in the Tort Claims Act. That's the Sampson case.
Well, Texas A&M could choose to provide some evidence, though, couldn't it?
Sure. Texas A&M, of course, can plead, and it could have provided additional pleadings. But this is already its fourth live pleading at this point. So if there were any additional facts that it wanted to include in its pleading, it's already had 4 chances to do that. I also want to be sure to address the premises defect claim as well, which in our view is squarely barred by the discretionary exception. The reason for that is because on page 9 of his brief, Mr. Fraley argues that really this is a case of negligent implementation, but the answer to that is no, it's not. The reason it's not a case of negligent implementation is because cases like Ramirez and San Miguel, which is sometimes cited as Miguel, as well as Rodriguez, very carefully explain that the design of a road, including what safety features to install, as well as lighting, which is referenced in the County of Cameron versus Brown case, all explain that those things are squarely barred by the discretionary exception. And the San Miguel case illustrates that point when it explains that the decision of whether or not to place barrels, the orange barrels that TxDOT places at the road sometimes, as opposed to if a construction crew might have placed them in the wrong spot, would have clearly been barred by the discretionary exception. And that's the easiest way to dispose of the premises defect claim. There is also an additional point that Mr. Fraley never pled actual knowledge that A&M knew of the dangerous condition, in contrast to knowing the simple existence of the intersection itself.
Why is that required?
That's required that's required from the Sampson case.
Well, but we have other cases saying it's not required. And for an ordinary premises liability claim, you don't require that the defendant have actual knowledge that the condition is dangerous. We only require that the defendant know of the condition. And so it seems to me that if our cases are right, and again, we have cases going both ways on this, but why shouldn't we clarify those in this case to say all that's required is that the defendant know of the condition, which A&M presumably did because they're the ones that took the roadway out?
2 answers to that. The first is the simplest way to dispose of the premises defect claim is on the discretionary exception. I think the more direct answer might be that reasoning would probably require the court to overrule the Sampson case, the Paper case, the city of which is the city of Denton v. Paper case, and the Keach v. Kroger case, and also the 1970 Carl Bayreuther and Associates.
But I can
case.
provide you 5 or 6 cases where we said that the knowledge has to be of the condition, not of that it is a danger. And why should the state have a different burden against it from any other premises owner?
Well,
And the restatement doesn't require that you have knowledge that the condition is dangerous, and that would seem to turn the premises tort into something like recklessness rather than negligence.
I think the Sampson case made you the best job of answering that question, Justice Busby, when it explains that there's a difference between simply knowing of the dangerous position. That was the case in which the UT law professor, Jack Sampson, tripped over the cord, the family law professor, and explains that UT must actually have known of the dangerous position of the cord, not merely the possibility that a dangerous condition could develop over time. And I think the answer to your question is that also implicates sovereign immunity, and there's a difference between an ordinary landowner versus the government's sovereign immunity from both suit and liability.
So waiving immunity for premises liability somehow changes the premises liability standard?
It may not change the common law as it relates to an ordinary landowner, but certainly our position is the court would have to overrule at least 4 or 5 cases, and on top of that, the court would.
Well, maybe not if it wasn't essential to the holding of those cases and it just misstated our other earlier cases.
I think it was essential to the holding of certainly the Sampson case, Justice Busby, and of course the court would also need in those situations to address the stare decisis factors that the court explained in the Mitschke case, which is that it must be in which the court explained that it must be necessary but not nearly sufficient that a prior precedent was incorrect.
Well, but wouldn't it be incorrect? I mean, we expect the legislature to speak clearly if they're changing the common law.
Sure. Well, as it relates to what the court referenced in the second restatement of torts, of course, that's the common law. That's not the legislature. But again, I think the court would have to overrule at least 4 or 5 cases, and would also have to undergo the Mitschke analysis and certainly overrule the Sampson case in order to get to that point. But certainly the court need not address that in this case because of the discretionary function exemption, and for that reason the court doesn't have to reach that issue. And another reason why the court doesn't have to reach that issue on the premises defect claim is because there's no allegation here that this T intersection, or simply where the road ended, was an unreasonably dangerous condition in the first instance. In other words, the definition of an unreasonably dangerous condition, this court has explained, as something where there is a sufficient probability that it could be foreseen that a similar accident like this would happen. And there's simply no evidence that A&M had ever received any type of reports or phone calls or warnings, as this court has discussed in the Pan American versus Aguilar case in the city of Reed, or the Reed versus City of Dallas case. And because there's simply no allegation that A&M had received any information like that, it would be very hard in our view to hold that this was even an unreasonably dangerous condition in the first instance. I also want to be sure to address the court's 4-factor test in the Hayes case as to why this was also not a special defect. And in that case, the court explained 4 things. It explained that first we have to take into account the size of the condition. But again, to the extent that there's no evidence on that point, that's a sovereign immunity jurisdictional problem that Mr. Fraley has not pled. It also, that test also discusses whether or not there was anything unusual or anything unexpected about the condition as to whether or not that's a special defect.
Would it be unexpected for someone who knows that there's a road, maybe looks at a map and sees a road continuing on, to suddenly find himself in a ditch?
So I think, Justice Young, that question goes to who is the ordinary user of the road, what Justice Bland and Justice Young were asking earlier. And we certainly submit that an objective ordinary user of the road should not consider subjective knowledge.
Is it subjective knowledge to know that there was a road there? That seems objective. It's a historical fact.
Sure. Certainly, the problem, I think, with the subjective knowledge test is there's a lack of a limiting principle there in the sense of whose subjective knowledge. Does it have to be someone that lives there and for that reason knows that, or does it have to be
Surely Texas A&M would expect that there are a lot of people who travel on the roads frequently, people who live in Brazos County, people who are in the law enforcement community that might not be on that campus every single day but are there from time to time or familiar with the road. That's not an unreasonable person or an extraordinary user, is it?
Sure, but We would certainly submit that we shouldn't consider any type of subjective knowledge at all, even if
I'm still not sure why it's subjective.
because if the question is, how did somebody know whether or not that defect in the road existed? How did
So you're saying that an ordinary user has to be someone who's equivalent to an amnesiac or something? Like someone who's the least informed possible person who's never been there before?
No, not someone who has absolutely no knowledge at all about how to operate a vehicle or how to drive on a road.
Or anything about these roads, but it's like every day is a new, like, oh my goodness, a T intersection. I've never been on this road before, like that level of unfamiliarity with the community.
Certainly a reasonable person is someone who has encountered various common types of intersections all across Texas, but not someone who has necessarily encountered that particular one or is even familiar with the roads of College Station.
So the Californian driving through College Station would be an ordinary user, but a sheriff's deputy who's part of that community would not be an ordinary user.
That's correct. And the reason for that is because the moment we begin to impute subjective knowledge, that could suggest that sovereign immunity is waived simply because A&M changed the road or because in other cases Texas.
What if the Californian had been following Waze? Let's say, I know that we don't have this record, but what if Waze or Google Maps or an actual map showed the Californian that it's not a T intersection, it's a road that keeps on going? At that point, would that be a legitimate ordinary user inquiry for purpose of finding whether it's a special defect?
I think that's another reason why the court should shy away from imputing any type of subjective knowledge, because of course different maps can be wrong about different things. And that's another reason that we should avoid using any type of subjective knowledge is because in some instances that can cut both ways. For example, it may very well be that Mr. Fraley knew that had previously been a T intersection, and that may count against him in this case.
But isn't it subjective to say that that's where A&M thought the road ended?
I see my time has expired. May I answer the question?
You may answer.
I think the answer to your question, Justice Busby, is that if A&M may have known that the T intersection ended, but that's different from whether Mr. Fraley, I might have missed the first part of your question.
I don't think we can consider A&M's subjective knowledge in deciding where the road ends, is my only point.
Sure, it may be that we shouldn't consider A&M's subjective knowledge of where the road ends, but we also shouldn't consider Mr. Fraley's prior subjective knowledge, if he had any, about where the road had previously ended. I see my time has expired.
Well, Chief, if I might ask, you're going to explain why we shouldn't allow this to be repleted. Is it just that there's already been a few chances, or is there some other thing? Because you started off by saying that it doesn't mention ditch. Well, that seems like something that maybe could be added, and possibly some other things. I want to make sure that if we agree with you that repleting is necessary, we understand why we shouldn't allow it nonetheless.
Sure. There are two cases that speak to this, Justice Young. The first is, which I alluded to earlier, is the Harris County versus Sykes case, which held that if a plaintiff has been provided a reasonable opportunity to amend after a government entity files a plea to the jurisdiction, and the plaintiff's amended pleading still does not allege facts that would constitute a waiver of immunity, the trial court should dismiss the plaintiff's action. Such a dismissal is with prejudice because a plaintiff should not be permitted to relitigate jurisdiction once that issue has been finally determined. That's at 136 Southwest 3rd at 639. The second case that speaks to that issue is Motson versus McLean. And that was a case in which the court held that Mr. Motson had already repleaded 3 times, and the court also explained that because he had advanced no viable theory of liability, he had not requested a remand for repleading in that case, but the court was specific to say even if he had, we would deny it because he had already been permitted to amend his petition to no avail. That's at 221 Westlaw 5977218 at star page 10. And those are the 2 cases that speak to that issue.
Thank you.
Any other questions? Thank you, Mr. Mendelson. Mr. McSwain, you have 5 minutes.
Thank you, Your Honor. Briefly, Justice Busby, I think I can solve your pleading issue about knowledge and awareness because I think that the pleadings in this case actually do plead awareness of a dangerous condition. As a matter of fact, that is exactly what they say in paragraph 3.4 of the plaintiff's third amended petition, page 211, I believe that's the second court report, clerk's record. It says defendant TAMU was aware of the dangerous condition / special defect on its property and did not properly guard against or warn drivers from the same. More than that, the cases Miranda and Jefferson that I've talked about before don't require that you plead all of your evidence. It's a Rule 47 pleading standard, which is simply a notice pleading standard, that says all you have to do pleading-wise is provide a short statement of the factual basis of the claims, and that has been done here. And I would point out, I've not yet seen a case, and I was listening to the last discussion with respect to the two cases that were cited. I believe, I don't have those cases at hand, but I believe in those cases that the courts said a couple of things. One, it's already pled a bunch, probably shouldn't do it again. But they also said, the ones that I read, there was a determination that irrespective of that, the pleadings affirmatively negated jurisdiction anyway, and so there wasn't any point. And that was specifically the case with the last one that the AG's attorney talked about, because in that one, that was the finding, and I think the court went on to say, we don't have to let them try again on some other theory of jurisdiction, right? But the court's cases, beginning with Miranda as the basis, say that with a notice pleading standard, if you didn't get it exactly right, if you didn't state quite enough facts, then you get to go again. You get to have another go at it.
What if there was a sign that had a T? You know how like a yellow sign with a black T? Would that have been?
My belief is if there was a sign that had a T that told everybody this was fixing to be a T intersection, we probably wouldn't be here.
Okay, so you're complaining about the absence of that sign, which puts you under 060 and means that special defect is your only way out of that 060 box because you're complaining about the signage.
I don't know that that's the case because we don't know, we can't tell from the record whether, despite the claims that it was built according to design, we don't know that. That's not in the record. Nobody has said that. There's not an engineer's affidavit that says, despite having 2 years worth of discovery, there's not an engineer's affidavit that says this was built exactly the way we designed it.
So has discovery been completed in the case?
No, ma'am. This case has been stayed because of this appeal. And so they were into discovery and again, not in the record, but apparently fixing to take the deposition of the A&M people, and this got filed.
But we do have the deposition of your client. I know there are excerpts.
We've got the deposition. I'm not sure that that's of my client. I believe that it's of somebody else that was there taking the trainer with him.
Someone who talked about your client approaching the intersection and what happened.
The waffle maze of streets and
The waffle maze of streets.
The waffle maze of
exactly.
streets. Let me point you to, with respect to the pleadings issue, Texas Department, TxDOT versus Olivares, 316 Southwest 3rd, 89, specifically says, the opportunity to amend pleadings that are insufficient to establish but do not affirmatively negate jurisdiction arises after a court determines the pleadings are insufficient. There is no case that says you get to plead 3 times and that's it. None. I would also point out.
So your point is that it's curable. Whatever jurisdictional defect that the Court of Appeals found.
Yes, ma'am.
Is curable.
If you guys, sorry. If the court will tell us what the rules are that then we'll either plead to meet it if we can factually or we won't. But I think that my client, since it doesn't negate jurisdiction, my client is entitled to replead.
Can we consider the pictures?
They're in the record. I think you can consider the pictures.
And wouldn't we consider the pictures in determining whether there's a possibility of the pictures are just what they are, right? And so there's no, well, what could they replead when you've got a picture that shows you what it looked like?
I believe that we put the picture in the record because we thought it benefited us. I believe that you have the right to consider the picture in determination of whether or not that would pose, given the circumstances and the 4 or 5 factors, a special defect to ordinary users of the roadway. Thank you for your time. I would ask that you reverse the Court of Appeals, allow Mr. Fraley to replead and press his case, given the lack of evidence in this record and that we're only on the pleadings.
Any other questions? Thank you, Mr. McSwain. Case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.